I am your immigration attorney, Michael Falwani, and
I am Lut Kazimochak.
so today's program is very interesting. This is about the children that were left behind. What does it mean by left behind? Because example is that if your brother citizen filed a petition for you a few years ago and the petition was approved and it's time now for the consular processing, for example. Now, once upon a time or for a long period of time, the law was that any children that were under the age of 21 could get derivative visa. So basically, in principle, the beneficiary, that is the person for whom the petition was filed, his wife or husband, and any children that are under the age of 21 at that time. Not only at that time, but if a child crossed one day, he's out. A child crossed one day in reaching the US, you are out. Believe me, I had a case long time ago where the flight got delayed by one day, and the immigration people say you are 21 years and one day, and therefore you are inadmissible. So that was very strict. So it was simple, see, okay, over 21 out, period. Now happens a change that takes place. The change that takes place is a legislative thing. Child Status Protection Act. This is the law that protects the children even if you have crossed 21 in some circumstances based upon a certain formula that may be possible for that child to be eligible for getting the green card with the parents. Now, what is the formula? The formula is very simple. The date on which the petition was filed is called a priority date. So let us say Immigration Service took 2 years to approve that. Alright? Now this calculation can only be made based upon when the visa number becomes available. So if you filed 7 years ago and now we have to see in the bulletin with the visa numbers available, on which date this case became available. On that date we have to make a calculation. The child is 23 years, let us say, and one day. And the difference between the filing and the priority date and the approval date is 3 years. So we minus the 3 years from 23 and one day, and the child goes back under 21. So this is the formula of CSPA that we can actually calculate only when a visa number becomes available, because that's based on that. So this is a good news, and a lot of children we have helped to come under the CSPA without much problems. Now, I'm going to ask Ludka a question here. Now, first of all, before I do that, a lot of people don't know, there's extra 45 days. If your petition was filed before 9/11, then in addition to the CSPA formula, you have extra 45 days under the Patriot Act, what we call. Okay, so that is the background of the CSPA and the relief that can be given to the children. I just want to ask you a question about other options. Let us say, we say, oh, he's out now, but the parents want to still bring him. Of course, one option is very clear. Parent comes first and he files a new I-130 petition.
But still, it will take a long time.
Long time.
Yes.
So question is, how quick, but you would say, we cannot, little girl there, unmarried girl, he's already 22, 23 year old. So going to 10 years, she cannot wait unmarried, and if she gets married, then she's out. So she cannot remain unmarried for another 10 years. Now what are the options that I was just thinking in my mind, like if she's educated, she has a college degree?
If she, for example, that's what I was thinking, if she has a bachelor's degree,
Correct.
she has an offer of employment, then we look at other options such as H-1B, non-immigrant visa, O-1, maybe she's an artist,
Correct.
famous artist of extraordinary ability, then we would look at O-1 or P-3, any other non-immigrant visas.
Right.
Sometimes those kids want to come here to study.
Correct.
That's a little problematic
But
because of
214B, the
immigrant
consul
intent.
is most likely going to
Yes,
deny. Yeah.
exactly. But dual intent visas such as H-1B,
And
maybe L-1
Yeah.
if they work for a company, these would be the options.
Another option is, of course, everybody knows that, but I want to repeat it, marriage. Marriage
Of course.
to a US citizen, marriage to a green card holder, it may take a little time, but they stop there. I said, don't stop there, go further. How about marriage to H1? How about marriage to L1?
Yes.
1 month. If you get married in H1, H4, you can come in a month's time. Obviously that eligibility under CSPA is not there anyway, so that goes out. That's how no you use anyway. So a girl or a boy, if she get H1 or L1 person, they can be here in 1 month, right?
Yeah, but definitely once they are here, even if in H4, in some derivative status, they should still go ahead with the green card through the parents.
Absolutely, because more likely it's possible that the H1 is husband or wife are already applied and is already in the line. So either that way or he can do that later, or she can also apply on her own.
Or maybe in the future we're going to be able to retain the earlier priority date. We'll see what happens with that.
So let me go forward with this thing. I said that the other option was an I-130 petition for a child when the parent comes in. CSPA, child could not come with the parent, but the parent is now here.
Yeah.
He has a green card. He can file an I-130 petition. We said that in that case he's going to get an old priority date. That means a lot of waiting period. However, there's been a lot of litigation, a lot of court cases were there in which the people challenged the policy of the administration to give them a new date. They say he should also get the same date, that priority date as that of the parent.
They should retain the earlier priority date.
So the parent's priority date was, let's say, 1998, for example. Then the children should get the same priority date. Now, we were hoping for a long time that based upon these court BIA decision and the court decisions, the government on their own administratively, like other administrative things, they should make that rule as a policy decision, basically. However, it hasn't happened so far, and the reason that it hasn't happened, I found out. I was going to fight for that. I was going to contact some lawyers and people, and already did that. The reason they did that is because this matter reached the Supreme Court.
Yeah.
So Supreme Court is now, any time, I'm telling you, I've been getting the news, it could be in a month, 2, or maybe earlier.
We are very patiently waiting.
Patiently, they will render a decision on the Supreme Court decision. I had the whole case copy also that's filed in the Supreme Court, and I believe there are very strong arguments that the courts are looking at, that the lower courts and the other jurists are looking at hopefully a favorable decision, because that makes sense.
That will affect many people.
Many children that are waiting.
Well, they're not children anymore. They might be 30
exactly.
by now.
It doesn't matter, but they'll still qualify.
Yeah.
They'll still qualify. So that's the best thing to happen. And if the Supreme Court decision does not make it, there's going to be a problem. You see, the one difficulty will be there, and that's the reason they didn't do it administratively, because they say that what's the point of doing administratively? After 2 months, the Supreme Court says that will override the administrative decision. The Supreme Court says that is not the legal. The law is that they cannot qualify. But my personal opinion is, based upon my analysis, that there are much better chances of the Supreme Court deciding in our favor.
Yes.
And then you have a big line in Ridgewood from here to here and there, all for the kids that will qualify. Kids, I can say, studios.
Yeah, I agree.
So I think that's all about today's program, and next program, another more important information. Please keep watching us. Thank you.
Thank you.